Mr. Herbert, were you ready with Mr. Gahn's matter?
I am.
Versus Arthur Gahn, case number 25160. Go ahead, Mr. Gahn. Record should reflect Mr. Gahn's present here in the courtroom today. And executive counsel.
Your court can be after the people.
Okay, and Mr. Herbert, the in receipt of a police report, do we have a plea agreement in this case?
We do, Judge. Mr. Khan, judge is going to tender a no contest plea to an added count 3, which is destruction of property, $200 to $1,000, which is a 1-year misdemeanor. It's 750.3778 1C1. Count 1 and count 2 will be dismissed. There's also an agreement of restitution that Mr. Khan would be paying. If there's any issues at the time of restitution, we set that for a hearing. But I think there's a restitution amount about $1,500 that we would agree on.
All right, so
That is correct. That's a correct statement of the plea. The restitution is $1,532.99. And that PAC code again for Ms. Medler is 750.377 A1C1.
and what's the basis for the no contest plea, Mr. Herbert?
Potential civil liability, Judge.
Mr. Gahn, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So
I do.
Mr. Gahn, are you currently on any kind of probation or parole?
No, sir.
You understand that the maximum possible penalty that you could face for this charge would be up to 1 year in jail?
Yes, sir.
Maximum penalty in mind for that charge.
No contest, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir, I do.
And you understand that by pleading no contest, you're going to be giving up and waiving all those rights.
Yes, sir, I do.
Has anyone threatened you with anything to get you to do that?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
And is it your own free choice to enter this plea?
It is, Your Honor.
I'm going to refer to Crawford County Sheriff's Department incident number 23-4089. I've had a chance to review that report prior to the hearing today. Ms. Cope, do you agree that the information contained within that report, typically pages 3 and 4 of 6, would 3, 4, 5 of 6, yeah, 3, 4, and 5 of 6 would establish a factual basis?
Yes.
I would agree, Judge.
Okay. So the court is going to mark that as court exhibit 1. The court will admit that factual basis for the plea. Ms. Cope, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor. And if we didn't say it, the maximum penalty is 1 year and or $2,000 or 3 times the amount of destruction or injury, whichever is greater.
Mr. Gurmurthy, are you aware of any threats, promises, or inducements?
No, Judge.
Ms. Cope, are the people satisfied that the court has complied with statute?
Yes, Your Honor.
Mr. Gurmurthy.
I would agree, Judge.
All right, Mr. Gann, the court finds that your plea is knowing and voluntary. The court is satisfied based on court exhibit 1 that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing hearing at a later date. And you're probably going to meet with either Mr. Haven or Mr. McFadden here before you leave the courthouse today. Ms. Coke, anything further that we need to address?
Just that we're going to remove the jury trial date that's previously been scheduled.
Yeah, it was set from November 13th or 16th and 17th, 15th, and 16th.
So the court will adjourn this trial date today. Mr. Gerber,
No, sir. Thank you.
all right, Mr. Gann, that's all for today.
Thank you.
Your Honor, if I may, as a victim in this case, would I be notified of the sentencing date to be here to have an impact statement?
Absolutely, that is your right pursuant to statute, so stay in touch with Ms. Koch's office, she'll inform you of that date, and yes, you absolutely have the right to come in and make a statement to the court.
Thank you, Your Honor.
People versus Prentice, case number 235153.
Just to repass on Mr. Prentice, when I just negotiated a no plea with Ms. Cole. I know Mr. Prentice was considering that. I need to talk to him to see what his decision is.
Right, how about Mr. Woods, are you ready on that?
He should be on Zoom.
Is you allowed to appear?
I think he is present, so. About Mr. Schlapp, is he present? Mr. Grimmer?
Mr. Slaff, I saw him outside, Judge.
Did we submit a warrant, ex parte motion?
On who?
Oh. It would have been today.
Huh?
It would have been today.
If you did it today, I have no idea because I haven't been in my office.
Okay.
And no one brought me anything in here, so I have no idea.
I'm ready on Mr. Slaff, Judge.
Okay. People versus Brian Schlapp, case number 235211. Record should be today, like the council was here.
Sierra Coke on behalf of the people.
Pretty all over the ground, I can get Mr. Slaff.
How did we want to proceed today, Mr. Grimmer?
Judge, I'll start by asking for the gentleman, I can explain that. Mr. Schlaff was set last week to meet with Lions Den and do an intake. Mr. Schlaff indicates that he was arrested for a failure to appear out of a district court matter. I don't know what that matter is, I'm not appointed on that matter. And that he was then taken to jail and he just bonded out of jail and that his appointment for the Lions Den is set tomorrow.
All right, let's go.
Your Honor, we prepared a motion to revoke his bond, but we just submitted it today. He tested positive last week while I was out of town for alcohol. So that will be coming to the court. They've already asked for an adjournment for the same issue. They asked for that adjournment on 9/8/23. So at this time, I think we should get it set for a trial if we're not getting this case resolved.
And I'm fine, you can set it in the trial after the police are updated. I'm unaware of any, I know Ms. Koch indicated that to me. I asked Mr. Schlaff if he was drinking. Mr. Schlaff indicated that there was no drinking issue. There was
Did you
Just
let me
found out.
check to see if there's any paperwork on my desk in regards to this ex parte?
I don't know, when did you file that, Ms. Koch?
I signed it this morning, but I don't know when they filed it. I sent my office a message, but Rachel's not here today.
First of all, with regard to the hearing, Mr. Grimmer, the court's going to grant one additional adjournment. We've only had one status conference in this case. So this one hasn't been out there an unreasonable amount of time. So the court will set this for a hearing in about 30 days. I am going to set that as a plea cutoff though, because I think by that point, we've had enough time here. If we don't have a plea on that date, that's fine. We'll set it for a trial date after that. If we do, then we'll go forward that way. Mr. Schlapp, the court's going to consider, I don't know what Ms. Koch has. I haven't seen it yet. But there's a possibility that your bond's gonna be revoked, so you may want to talk to Mr. Germer about that before you leave the courthouse today. But as of now, it hasn't been signed and I haven't reviewed it, so I may not want to go far because that's gonna be an issue we need to deal with. I understand. So I would talk to Mr. Germer before you leave. Otherwise, we'll be back in 30 days.
Thank you.
And then we have looks like Mr. Woods on video. Mr. Woods. let's see. Mr. Woods, I just need you to unmute, please. Thank you. All right, are you able to hear me okay?
Yes.
Okay. All right, we're on the record in People versus Dennis Woods. This is case number 2352201. Mr. Woods is appearing by Zoom today by prior approval of the court.
Sierra Coke on behalf of the people.
Okay, all right, we're doing what we can here for Mr. Woods.
Mr. Germer, can you tell me where things are at with this?
Yes, the plea offer in this matter is to plead count one of fleeing and load in third degree as a habitual second. Count two, resistant obstructing police officer will be dismissed. Count three, for operating without a license, either suspended, revoked, or denied, will be dismissed. And unlawful use, count four, including the habitual fourth offender notice, would be dismissed. Mr. Woods has indicated that he intends to take advantage of the plea offer, but I don't have a confirmation as to whether that's what his intent is or isn't.
Okay,
I will also apprise the court, Mr. Wood is on probation in Oakland County. I've indicated that if he tenders a plea here, it would revoke or at least violate him with probation in Oakland County.
okay. Ms. Coe, just to confirm, the plea offer is to plead to count one as a second habitual offender, is that correct?
Yes,
And all other charges will be dropped?
yes.
All right, Mr. Woods, have you been able to hear all that we've said here today?
Yes. There's a few things yes, I did hear you. Yes.
Okay, did you want to proceed with that plea today, or did you want to have this case go forward to trial?
I would like to plead. Do have a concern or a question. Does that violate my probation immediately, or how does that work?
That's up to your agent there in Oakland County. I don't know, have you talked to them? Do they know that you're going to be entering a plea in this case?
No, sir.
Okay,
No, sir.
so, yeah, so I don't know what your probation agent will do there in Oakland County. I don't know, the circumstances of your probation there. But typically, they would find out through our court or through you telling them that you've entered a plea in a case here in Crawford County. And then they'll make a decision about whether or not they're going to violate your parole, and then, where that would go. So but I can't speak to that as part of this case.
And Judge, I'd also like to make it clear, Mr. Woods has asked me if I know what he's going to get by way of sentence. I told him what his guideline ranges are. I don't know what his sentence is going to be. And I told him that in Crawford County, we don't do what downstate courts might do by sentencing agreements pursuant to Brooks Killebrew, and that sentencing is up to the judge in this county. So I just want to make sure and put that on the record as well. There is no sentencing agreement in this plea.
Okay, Mr. Woods, did you have any other questions?
I mean, along with what my attorney just said, I know what I'm pleading. Okay, but I don't know if it's any further steps I need to take, because I'm trying to see if I could work with my probation in Oakland County. I don't know what I'm pleading, what time I'm accepting. It's by just saying, yeah, I'm guilty. I don't know. It's like I'm in the dark.
Yeah, so Mr. Germerthy's gone through your guidelines with you, but I haven't seen a pre-sentence report yet. I don't know what those guidelines are. And so that's something that I find out between now and the sentencing date. I get a pre-sentence report after they talk to you, and the probation agent here will score the guidelines, and that'll be part of a report that I get. But sitting here right now, I don't know anything of your past record. I have no idea what your case might score out at this point.
My next sentencing, my next court date the title for that date would be what? Because
A
today is status,
sentencing hearing, if you enter a plea today.
a sentencing hearing. Does that mean it's over with? The next time I come, it's over with, or I come back after that too?
No, the next time would be a sentencing hearing in person here in Grayling, and that would be the final hearing of your case.
Then it's over. It's no more court after that.
Correct.
So I don't find out. So I plead guilty today. Don't know how much time I'm doing, and then when I come next month, you tell me what it is, and I accept it, and that's just the end of the case.
Well, you'd get a copy of the report before the sentencing date, so you would know what your guidelines are and what the recommended sentence is prior to you coming to court on that day.
Okay.
I should also make it clear for the record, Judge, I did go over Mr. Wood's mitigating factors. He is in treatment. He is seeing an outpatient therapist. I have some letters, and I indicated that at the time of sentencing, we would apprise the court of those other mitigating factors as well. And all those things would go into a sentencing judge's decision on how to sentence somebody. So I've talked to him about that issue as well. And I've indicated that that would be here in person at the next hearing if he decides to enter a plea today.
Okay, so Mr. Woods, how did you want to go forward today then?
I don't want to waste anybody's time. I feel like I can plead guilty. I just don't know what I'm walking into though. I don't know if it's any more information needs to be gathered up on my behalf. Cause I really don't know how to answer. I would just rather my attorney answer for me. I don't know how to answer that because
Mr. Woods, if you plead, Mr. Woods, if you plead today, you would be meeting with somebody here in Crawford County, a probation officer, and work with them going through a package that you have to fill out. And then additional information will be gathered at that point. Remember, I told you that between now and coming back at sentencing, you would have to talk to your probation agent, and some of the letters that Patrice has sent to me, I would submit that as well, so they can attach that to that pre-sentence report. So that'll happen between now and when we come back. Your sentencing date could be either in November or in the early part of December, depending on how the judge's docket falls.
Okay.
So we'll be back in about 4 to 6 weeks' time.
Okay.
So none of those things have changed, okay?
Yes. So I'll have my guidelines before the date.
Correct.
Okay.
So did you want to go forward with the plea today then?
Yes.
All right, Mr. Woods, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. And so the charge that you've been pleading to is fleeing and eluding third degree as a second habitual offender. And that means that the maximum possible penalty that you could face would be up to 7.5 years. Do you understand that?
Yes.
And then as we've discussed, you're going to have to talk to your probation agent in Oakland County and find out how this is going to affect your probation. You understand that?
Yeah. See, I have to say what I have to. I haven't been told none of this. I was told maybe jail time. I haven't been told none of this 7 year stuff. I ain't know, so I don't know what to say. I don't know what to do. I don't know what to say. I hear
Mr.
you.
Woods, Mr. Woods, we talked about your maximum sentence, correct? You should always know what's your maximum sentence. And that's what the judge is going over, that your maximum penalty is up to 7.5 years. That does not mean you're going to get 7.5 years, but that's what your maximum penalty is.
Okay.
He's just covering what you and I talked about, but he has to do that on the record to make sure you understand what the maximum penalty is.
I understand what the maximum penalty is. Well, I'm not saying that that's what, hey, I want to do that. But I hear what you're saying.
Right, and nobody has any authority with the maximum penalty. It's what the legislature has set the maximum penalty to be. This is not some magic number the judge came up with or I came up with.
Yes,
It's what by statute, by law is the maximum penalty. We've covered those things.
yes.
Okay, so then with that in mind, what is your plea to that charge today?
Guilty.
So I'm gonna go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes.
You understand and you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
Not a threat, but idealistically, my mind was being told that, you know, what I had just stated to you. So that was what I was backing off of.
I have no idea what that means. Has anybody threatened you with anything to get you to plead guilty?
No, but I was kind of like I guess pulled in to plead guilty with the idea that I'd be possibly getting jail time. I mean, I can keep saying it, but that's only my thinking. I heard it and I understand it. I'm still going to be honest and say I'm really not sure how to proceed. I know I'm guilty. I just don't know what I'm walking into.
All right, so Mr. Woods, I'm going to set this for a plea hearing at a later date. I'm going to give you one more opportunity to talk to Mr. Gurmurthy about the potential consequences of your plea. But you're going to have to do whatever you have to do over the next 30 days to make sure that you understand this, because I'm not going to come back in 30 days and have you continue to tell me that you don't know what's going to happen and you don't know this and you don't know that. So
well,
it's going to be
I got an idea, but talking to you versus talking to out of respect to both of y'all, it's like two different things. Even though he did tell me, it's still a possibility it is. So me pleading guilty is a part of me hoping that, okay, because these things were said, not a threat, but almost I had basically like, yeah, it's possibility you could probably just do some jail time or something like that. But I'm trying. I just don't know, but I'm willing to do what I got to do to comply with the courts. But I'm honest. I don't know what's going on for real.
That's what I'm telling you. So I just want you to listen real careful to what I'm about to say, okay?
Yes.
Over the next 30 days, whatever you have to do in terms of talking to Mr. Gurmurthy, your lawyer, it's up to you to talk to him and make sure that you understand everything and ask all the questions that you need to ask so that when we come back into court, you understand everything. That's number one. Number two, you need to call your probation agent and find out how it's going to affect your probation there in Oakland County. And so whatever you have to do to get a hold of that person and get those questions answered before the next time we come into court so that you're ready. And what's not going to happen is the next time we're in court, we're not going to have the same conversation where you're not clear on things, because if you haven't done it by then I'm going to assume that you don't care that much about it and you haven't made those inquiries. So, but when we come back next time, you need to have your questions answered, and the responsibility to get those answered is on you. Okay?
Yes. So the next one will be a status hearing again, or,
You're either gonna plead guilty at the next hearing, or I'm gonna set it for trial, and there won't be any more pleas, any lesser charges.
okay.
All right?
Well, one last concern that I have, I do live like 4 or 5 hours away from Crawford County. And I am like dealing with a few things here. I don't have a car. I can't drive. I'm in trouble right now for driving. Don't want to take a risk of driving. I don't have any family here. Is it any way I could proceed with my Zooms? I would like, I don't know how I would do it, or I would have to get a hotel and everything coming down there, because to my knowledge, the bus comes once a day, which means I'd have to leave the night before to get there in the morning.
Okay, I'm just gonna cut you off because I got other cases, and you've already told me all of this, and I understand your transportation problems. And well, the next hearing will be by Zoom, but if you're found guilty at a jury trial, which you'll have to be here in person, or you plead guilty, the sentencing hearing, you're gonna need to be here in person. So at some point, you're gonna have to come up here. You got yourself into this mess up here in Crawford County, and you're gonna have to come here at some point and deal with it.
Right.
So however you get here, that's not my issue.
All right.
The next hearing will be by Zoom. After that, you'll have to be here.
Okay.
We'll start planning for it.
Right.
Okay, thank you. That's all for today.
Thank you, Judge.
Mr. Are we ready? Oh, you need to talk.
I do, I need a few minutes in this practice, Judge. Mr. Way's, but give me a few minutes on some funds.
Let's take a short recess. We'll come back on the record in about.
Thank you.
People versus Prentice, case number 235153.
Sierra Coke on behalf of the people.
Judge, Mr. Prentice is here in the courtroom. I'm ready for the hearing. He's just testifying.
How do we want to proceed on this case?
Judge, after some further negotiations into this afternoon, there's a new plea offer that Mr. Prentice would like to take advantage of. Mr. Prentice is going to plead to delivery of a controlled substance less than 50 grams. It's still a 20-year max, but it is a D good offense. And in lieu of that plea, counts 1 and 2, felony information be dismissed.
Okay. Are we still taking the factual basis of the substances methamphetamine?
Yes, sir.
Ms. Coke?
As a correct statement of the plea offer.
Mr. Prentice, have you had a chance to go through this with Mr. Germer? Yes. How do you want to proceed today? Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Mr. Prentice, are you currently on any kind of probation or parole? All right, you understand, as Mr. Germer indicated, that the maximum possible penalty you could face on this charge would be up to 20 years and or a $25,000 fine. With that in mind, what is your plea to that charge? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights, and you understand that you're giving up, waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today or to have it reversed. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of any appeal. Do you understand that?
It means what, I'm sorry?
So the plea that you're making here today, if you wanted to try to reverse it or take it back, you don't have an automatic right to do that.
Okay.
If you wanted to try to do that, you have to ask the Court of Appeals to hear your case. But if they said no, then that would be the end of it. You wouldn't be able to go any further.
Okay, and when you mean reversed, as in, like, what do you mean reversed? Because
So the guilty plea that you're entering today, you wanted to have the court, erase that or take it back or.
to go back to the original.
Yes,
Okay.
exactly.
Okay.
That you don't automatically have the right to do that. And if the court were to say, no, you can't do that, the only thing you could do is ask the next court above me, the Court of Appeals, to hear your case, but they don't have to hear it.
Okay.
They can say, we don't think there's a good reason. And that would be that. Do you have any other questions about that part? Okay. Has anyone threatened you with anything to get you to enter this plea? Has anyone promised you anything other than what we said here on the record? Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Okay, so this happened on, it's like a while ago, February 17th of 2021. Is that the correct time frame? On that day, were you here in Crawford County?
Yes.
And while you were here in Crawford County, did you have possession of some methamphetamine?
Yes.
And did you give or sell that to another person?
It was his intent to deliver, Judge.
Okay. Is that what Mr. Germer said? Is that correct? Yes. Did you have any legal right to do that at that time?
No.
Ms. Coke, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Germer? Coke, are the people aware of any threats, promises, or inducements of the correct?
No.
Mr. Germer?
No, Judge.
Ms. Coke, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
I would agree, Judge.
Mr. Prentice, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. It's important Leading up to that hearing, that you stay in touch with Mr. Germer, please, so that you're prepared for that day. Before you leave today, you're going to need to look for probation. Thank you.
Thank you. And Judge, that should take the 13th of November trial off the docket.
Yes, the court will adjourn the trial date in light of the plea today. Thank you. People versus Ray, case number 235410.
Here, could we have the people?
General Revenue, Mr. Reyes.
Reflect Mr. Ray today. This is the date and time set for a sentencing hearing in this case. Mr. Ray, if you have a chance to go through the pre-sentence report and talk to Mr. Germer about it. Are there any additions, deletions, or corrections to that report?
No, sir,
Just exploring it, guys.
none.
But do people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring of the guidelines?
No.
Anything on behalf of the people for allocution?
I think the recommendation is appropriate, given his lack of criminal history and the plea offer that was given in this case. I'd ask the court to follow it. Thank you.
Thank you, Mr. Germer.
Judge, if I want to allocation, the court received some attachments that I submitted, such as his drug test with Child Protective Services, and he was in that history.
Yes.
Okay, thank you. Judge, Mr. Ray is 32 years of age, very minimal criminal history, 2 prior misdemeanors. This is his first run with drug offenses with the court. We'd ask the court, at least at the time of the plea, to put him on 7411 status. The recommendation is for 7411 status. We'd ask the court to put him on the special 7411 status. Mr. Ray was testing with Child Protective Services early on prior to this case even being adjudicated here in the criminal matter. He's tested negative. There is a child neglect and abuse case proceeding that is pending in the family division, and Mr. Ray is going to tender a plea that is going towards reunification with his child. I think there's a lot to lose for Mr. Ray if he violates terms of his probation and doesn't stay on the 74 status. He doesn't have an opportunity to wipe this plea from his record and then reunify with his children. For all those reasons, I would ask the court to follow the recommendation. I don't think Mr. Ray will be back here in the court again, Judge. Thank you.
Thank you, Mr. Ray. Is there anything you wanted to say? So I did read through the report. I'm familiar with what happened in this case. There's also a lot of information there about your background and circumstances. And I did review the documents that Mr. Germer submitted. And it does appear, you're off to a good start here in terms of being successful on probation with the negative drug screens. And so I think it is appropriate to place you on probation pursuant to 7411. Give you an opportunity to work on the family end of this, but also through a successful completion, not have this be a felony on your record, which is, going forward. So I hope that you continue to take it seriously. I hope that you continue to do what you need to do to maintain your abstinence from substances and follow the conditions of probation. The court is going to place you on probation for a period of 12 months pursuant to 7411. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. So it's important for you to go through all of that with your agent so that you understand all the conditions that you can be subject to during probation. The court is going to order that you serve 5 days in the Crawford County Jail with credit for 5 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, a state cost of $68, and a fee while you're on probation for supervision of $30 per month. Because this is pursuant to 7411, there are no written appellate rights. Ms. Koch, is there anything further for people on this file?
No, thank you.
Mr. Germer?
No, sir, thank you.
That's all. Just make sure you check in with your probation agent.
Right, thank you.
Are you ready on Ms. Conley's matter, Mr. Chairman?
I am Judge, if I could just have one moment with this comment. I am Judge.
And
It's like Spanish interpreter.
that's what I'm just checking on right now, so we do have. Bopple. Is the interpreter, Mr. Grimmerly, getting in contact?
No, I did not see an order signed regarding any, so I was not aware.
Sign that right at the end of last week. Ms. Koch is, Rosa is that, in this case, she's a victim.
She is the victim.
Does she need an interpreter?
No, the interpreter's for the grandma.
Okay. Is grandma here? And what's her, is she a victim too, or?
No,
Okay,
she's not a victim in the case, but she was a witness in the case and she was present during the incident that occurred.
are we gonna be taking testimony from her or something?
I don't believe so. I don't believe under the Victim Rights Act that she would testify to
So
anything.
why are we having an interpreter?
Because if I went,
Again, if the court were to sentence her, the recommendation is no jail, but if
Right.
the court were to, there's children and other
Okay.
issues, so we would know what happened in court.
Understood, okay,
We're just preparing, we don't know what the court.
sure, I just wanna make sure that there's a few moving parts here, I wanna make sure we have everything straight before we get started, okay, so. It looks like we do have everybody connected. Mr. Bopple, are you able to hear me okay?
Yes, I can hear you fine.
Am I pronouncing your name correctly?
Yes,
Okay, so I'm not sure if we're gonna need you and to what degree we will, but if we do, then I'll unmute you, okay?
okay, sounds good.
Thank you, I appreciate it. Okay, so this is the date and time set for the sentencing hearing in this case. Ms. Conley, have you had a chance to go through the pre-sentence report?
yes, I have.
And have you had a chance to talk to Mr. Germer about that?
Yes, there were a couple things.
So Mr. Germer, are there some corrections that need to be made to the report?
Because there were some corrections that needed to be made, this is the pre-sentence report regarding substance abuse. Ms. Conley doesn't have any substance abuse issues and doesn't have any history of substance abuse. And just doesn't that portion.
Where is that? I'm just looking at space pages. That substance abuse history now.
It's on page 2.
It was page 2, Judge, and I just want to make sure that as long as, when it talks about assessments, that those were simply assessments based for the domestic violence intervention, not regarding substance abuse, that those things were clear.
I guess I'm gonna need one of you guys to tell me what we're looking at.
So Judge, it's page 2. The second paragraph. It's not one of the numerical numbers, it's the one above it.
Oh, I see.
It doesn't show the terms of probation where the numerical numbers are, it's the paragraph above.
Those talk about goals for during probation. They don't indicate that you have or have had a substance abuse problem. Those are pretty standard things that we want everybody to do, whether they have a problem or not, is to maintain sobriety, remain crime-free, complete any substance abuse counseling that is recommended for you. Those are recommendations that are made in just about every case. I certainly don't take from that you have currently a substance abuse problem or that you have had one. And again, it does indicate on the face page that there is no substance abuse history. Mr. Gurmurthy, any other corrections?
There were some corrections to the Dr. Fenton's, we'll go back and make that on the record.
To what? I'm sorry.
To the risk assessment, but we can make those on the record in elocution. Judge.
Okay. Any other corrections?
No,
Guidelines here, Ms. Cope, do the people have any additions, deletions, or corrections?
No,
And does the victim wish to address the court?
it is my understanding that she does.
Okay, so Rosa Conley, I'm gonna need you to unmute on your end, please. Are you able to hear me okay? Okay, I'm gonna probably need you to get a little bit closer to whatever device you're using or the microphone, because I'm not hearing you very clearly. Can you say something again so I can test the audio?
Yes, Your Honor.
Okay, that's better. Can you tell me your name for the record, please?
My name is Rosa Conley.
Thank you. And what is it that you would like to say here today?
I have my statement. So do I just read it from the top?
Yep, that would be fine.
Hello, Your Honor. Thank you for taking the time to listen to what I have to say. I'm Rosa Conley, Juana Conley's daughter. On November 30th of 2022, I lost everything. I lost my confidence, my strength, and my entire family. My mother took that all from me. That night was by far the worst night I ever had. On that day, I had cleaned everything and was doing so well in school, and I was proud of myself. I was trying so hard to give my mother reasons to be proud of me. She had been gone for hours. When she finally came home, I was eager to meet her. Excited to share my progress, I had no idea my life would change forever. When my mom came in the house and started a conversation with me, we talked a couple minutes about what I did that day. She then asked for my computer. I hesitated because it was the only way I could connect to the world. I asked her why. She then started raising her voice, and I was used to that, but it put me on edge. So when she reached for the computer by force, I knew it was, I guess I went into fight or flight mode. I tried to leave the room, but my mother and grandma stood in front of me and locked the door and the bolt locked. As soon as I knew I was trapped, I felt terrified. I looked for ways to escape, tried screaming and yelling, calling the cops, or please stop. I saw an open door to the bathroom and tried to make a run for it, but as soon as I did that, I felt her grab me. She missed the first time, but she got a grip on my sweater and I felt my throat get tight. I fought and fought to get out, but my throat was getting tighter and tighter. I cried for help. I started to feel lightheaded, and I started to see white spots all over. I knew I had to give up. After 2 to 3 minutes of struggling to breathe and squirming around for help, she threw me on the ground and I scooted back to the bathroom to try and the door. She then stepped on me and put her knees on mine. I couldn't move. The look on her eyes is something I will never forget. She wasn't the mom I had seen growing up. All I saw was a monster who wanted me to be in pain. I was against the bathroom sink, crying, yelling, and telling them to get off me. I didn't fight back. I couldn't fight back. I then got slapped by my grandma as I'm being called a drug dealer and terrible things. At that time, I knew I couldn't do this anymore. I threw everything and tried to leave the room. My mother was sitting in the rocking chair, and I told her I'm leaving to call the cops. Her response was, "Oh, you're gonna go meet someone. You're gonna go use your boobs. You're gonna go use your ass. Oh, I know you're gonna use your pussy." What kind of a mother says that to a 17-year-old daughter? As all of this was happening, all I could think about was my brothers behind that locked door. Could they hear me screaming and crying? If my mother was capable of strangling her daughter, what about my brothers? Are they going to be okay with that when I leave? When I left, I was struggling to catch my breath. I went to my neighbor's house to call the cops because I wasn't allowed to have a phone. and my mother refused to let me use hers. As I began walking, she said, "Good luck on getting the cops." I had walked out and I never would have thought that would be the last time. I risked it all, but I knew I needed help. When the cops came, they knew I was in danger between the bright red marks on my neck and the bloody scratch marks. I sat in that cop car feeling so scared and betrayed. This was the mother that was supposed to nurture and care for me no matter what. And what did I do wrong? Why me? I just wanted to be loved. At the time of the arrest, I was on probation and tether for running away. I had tried to tell so many people about the way I was treated. I went to so many mental hospitals because I hated my mother. I was a child, her child. I deserved better. I deserved to feel love. I wanted to feel love so bad so I can continue to run away. I was not heard. Nobody believed me because my mother is a narcissist and everybody believes her over me. I was getting in trouble for smoking and sneaking out. There was a reason behind it. I smoked away my pain and I snuck out because I needed a break. I was controlled like a prisoner. I was never able to leave my house. A long time before I ran away, I couldn't go in the backyard. I couldn't go on walks. I could only wear certain clothes. I couldn't go to school. I begged for help and not one person heard me. I wanted my mother to love me so bad. I wondered why I was treated so differently and why I am always a problem. My mother always told me how good things were when I was asleep or not there. I guess she got what she wished for. Her baby girl is in foster care. I'm all alone in the world now. I don't get to be with my brothers who I loved unconditionally. I don't get to have holidays, birthdays, or special occasions with my family. Mom, I was your daughter, not your dog. Foster care is terrible. I have to deal with waking up with nobody by my side. I have nobody to call and tell me about my day. I have no one to be there when I graduate. I have no one. My mother told everyone in my family, "Don't take Rosa, she'll just get you arrested." My mother got arrested and charged because of evidence, not words. Nothing I said to the cops compared to the marks on my neck. I want everyone to know I did not deserve this. I did not deserve to be treated like I was nothing. I did not deserve to be told I did not deserve to get strangled. I have severe PTSD from this crime. I have nightmares. My mother deserves to feel the pain I felt. I was never loved, and it was proven at a court hearing when they asked if she's willing to change and get me back, her answer was no. You didn't want your daughter? I didn't ask to be born. The thing that gets to me is that I did cry out for help so many times. When I was put on probation for running away, I told the judge I would do it again because of my mom. There was an ongoing investigation from when my mother had me in chokehold a couple weeks before her arrest. I tried to get somebody to hear me. The fact that I was always locked in the house and unable to even go outside said something. I tried so hard not to do stupid things that at some point I gave up. I felt trapped in my house like nothing would get better. The days leading up to the incident, I wasn't able to sleep alone or go to the bathroom with the door closed. I was constantly being controlled like a puppet. I failed 3 grades in a row because my mother refused to let me go to school. I remember crying to her, asking her, why can't I be a normal kid? I became really antisocial and I have social anxiety due to the lack of interaction with other peers. I also struggle with confrontation because every time I would talk to my mother, it would turn into screaming. I learned that speaking up was talking back. I now have to unlearn all the toxic habits and behaviors I was taught. In the end, I feel like CPS has failed me and they didn't listen to me until I got strangled. I also didn't agree to my mother's plea deal because a crime so bad leading up to me being put in foster care shouldn't be brushed off like it's nothing. I'm the one who has to suffer when she gets what she wants. My mother won't be there to watch me grow when I have my first child, when I graduate, and when I get married. By choice, she decided to give up on me. She walked out and left me to face the rest of my life isolated from my family and damaged. I was a child. You can't grow up hearing you are a terrible person and not start believing it. It took months of therapy and a lot of support from others, but I am doing better than I ever did while I was with her. I am finishing high school a semester early. I do not smoke. I do not drink. I go to school and have friends, and I'm working towards the goal of my future. I no longer have someone abusing me to run from. I'm no longer trying to escape the pain of my home life. Foster care is a lonely, sad existence, and I'm scared to enter the adult world without my family's support, but I know that I will succeed. I will not give up on myself. I will grow up and I will work with children. And when they tell me that they are being hurt, I will listen. I will have a family, and my children will always know that they are loved. So I'm asking you, Judge, will you please listen to me this time? Can my mother get the consequences for her actions instead of me? She abused me, and now I'm all alone in this world. How is this justice? She deserves a punishment that will make her know how it feels like to not be heard and all alone. This is my story, and I'm tired of her playing the victim. She had her chance to change and get her act together, but she didn't. So she needs to be held accountable. Thank you for your time.
All right, thank you. Ms. Koch, anything that you wanted to say for purposes of allocation?
And I think the PSI states a lot of the issues. I think the family definitely has some issues, and those are put forth in the PSI, and the court's probably heard quite a bit of it now from the victim. I think the recommendation is appropriate. We were looking for a plea agreement that addressed all of the family issues and hopefully will allow some rehabilitative efforts on the defendant's part, which it sounds like she's trying to work on, and for all of the family members. Thank you.
All right, thank you. Mr. Grimmer.
Judge, I would just ask the court before I allocate that the court hear from Ms. Conley first.
Okay, Ms. Conley, what would you like to say?
Unfortunately, they did not take my mom's statement on the day of that all this happened.
Yes.
Had they would have known that, because the way Miss Rosa recounted it is not the way it happened. The only time that her sweater was pulled on was when she was running in to my mom's room, and she had pushed my mom down less than a month before. So when I saw the look on my mom's face that she was scared when Rosa ran in there with her computer, that's when I grabbed the back of her sweater, and that lasted all of about 20 seconds at the maximum before I realized that she was going to go in the room regardless. And unfortunately, like I said, because the officer Ladlow and the former officer Nowakowski would not get my mom into her side was never heard, because in all reality, my mom was the victim of Rosa, and we've all been the victim of Rosa. Because now, I mean, our family is doing great. My daughter, Aaliyah, and my son, Daryl, are here, and things are going very, very well in our life. And, you know, I understand now that I acted like preemptively by grabbing her sweater. Now I know that that's considered domestic violence, no matter what, because I didn't let her harm my mom again. But I guess that's how it's supposed to happen. I should have let her do something to my mom. But again, my mom was never heard. And had she spoke English, you know, she would have been treated like an actual human that had a right to, you know, have her side heard. And my son Daryl and Legend were there for the entire thing. Rosa thought she was going to get in trouble with her probation officer, which is why she didn't want to give the computer over. And the last thing she said, which my son Daryl heard her say, is, "I'll make sure you go down with me." And that's been her goal. That's been her goal, is to paint me as the spawn of Satan. And, you know, so here we are. But again, my daughter Leah is here. We have an amazing relationship. My son Daryl is here. We have an amazing relationship. But had I not been protecting my mom. I mean, I wouldn't have grabbed her sweater for the 10 seconds that I did. But there was no other abuse as she's stating.
Thank you. Mr. Gerber.
There's no doubt that these are unique family dynamics between Rose and Juana. But I think the highlight is that at trial, I think there would have been a lot of evidence that would have come out that I think would have ended up with the same result that we're here in the court today. I don't believe there was any strangulation other than tugging on the sweater of the back of that sweatshirt for Miss Rosa Conley. Now, was Miss Juana Conley wrong in doing that? She was, and that's why she tendered that plea in the way she did that. There was no defense of others at the time. There was no self-defense at that time. Had she waited, perhaps that would have developed into something more where she would have had that defense. But that didn't give her the right to grab the child in that manner. Subsequently, Child Protective Services involved. They removed Rosa from her care, but the other two children remained in her care. And I bring all this up just so the court has the understanding that she is not this terrible person who's abused her other children or strangles her other children or has put her other children in any harm's way. That all the other kids are in the home except Rosa. We did a risk assessment. I think the risk assessment addresses some of the underlying issues, that she's not a risk to other children, but clearly the dynamics between Juana and Rosa just don't mesh. And we argue for that very reason. She is doing well with Child Protective Services. I think there's one of two issues that are going to come up with that case, either expand on some further psych evals or ask the court to close that case as well, because she is doing well. There is no substance abuse history. She has no prior record. This is the first time with the court involvement in proceedings. And there's just a lot of evidence of Rosa's mental health issues, her being on probation, what put her on probation, and why Ms. Conley, and I understand why she reacted that way, but again, under the law, if she would have just waited for something to happen, or at least if Rosa would have portrayed that there was harm occurring to another individual that was imminent, she would have been, able to assert that defense of others is a self-defense claim, which just in this case, the evidence didn't support. The timing didn't work out. I bring all that because, again, I think Ms. Conley was acting in that manner that she reasonably, as the parent and guardian, could discipline her child. I think it went a tad bit too far, and she's here. She's accepted her responsibility. She's here for the accountability of her actions. I think the recommendation is well within reason. There's numerous letters of support that we've submitted to the court. Families here, and if the court wants to hear from family members, I know her daughter would like to address the court as to their relationship. So we shed some light as to how Ms. Conley is in the house, and she's not this person as Ms. Rosa Conley is trying to paint her out to be. But with all that being said, I think some probation would be fine. She would pay her fines and costs, but the court is not going to put her on probation, given that there is a Child Protective Services case that is being monitored. I would be fine with that as well, Chair, but I will leave that in your discretion.
All right. I did have a chance to review the report. I've listened carefully to what everybody's had to say here today. And it does sound like a really unfortunate home situation, and a really difficult dynamic between you and Rosa. And what happened on this particular night or day, it's hard. I'm reading words on a piece of paper. I hear her version and I hear your version, and they're very different. And it's been my experience generally that usually it's somewhere in between there because of the way that people perceive events. And so I'm sure there's some truth on both sides of the issue here in terms of what actually took place, what level of threat there was, whether you needed to take the actions that you did, whether it was preemptive, whether it was justified, and so forth. I do think that, you don't have any prior record. Typically, if people have a problem with violence, then that shows itself before this stage of life. And so that tells me something that you don't have any prior issues with this. I do think that the delay of sentence is an appropriate resolution here. I think it provides a degree of oversight. You're going to have to answer and follow some conditions for a period of time. That in and of itself is a penalty in my view. There's certainly a financial penalty here. I think that addresses the wrongfulness of your conduct, also provides some assurance on behalf of the community that if you're able to successfully complete the delay of sentence, that, you know, this isn't a problem that's generally going on and that will be a problem in the future. And then the delay of sentence, again, allows you to have the benefit of the bargain in this case as well, in terms of your record going forward. So I really think that the resolution does kind of address all the needs all the way around here. So the court is going to follow that recommendation, place you on a delay of sentence for a period of 1 year. The court is going to adopt as the conditions of that delay all the terms and conditions listed in the report. The court is going to order 1 day in jail with credit for 1 day served, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $50 state cost, and a supervision fee during the delay of sentence of $30 per month. Because this is a misdemeanor, there are no written appellate rights. If you had questions about the ability to file an appeal of the sentence, about that, but if you wanted to do that, you would need to file. So there's a time limit on that. Other than that, I'm just going to add, Mr. McFadden, are you going to be supervising?
Yes, I am.
Okay, so if you just want to check in with Mr. McFadden.
And I have, I added up the amount that's on the PSI, which I came to 855. I don't know if that's correct or not.
Take care of the books.
Yes.
But I have that in full to pay today.
Yep, and then just check in with Mr. McFadden, he'll explain that process to you as well. Ms. Koch, anything further on this file today?
No, thank you, Your Honor.
Mr. Gerber?
No, sir, thank you.
Ms. Conley, do you have a check or cash?
Cash.
All right, thank you. That's all for today, Mr. Boppel. Thank you for being present. It doesn't look like we're gonna need your services, but we appreciate your time this afternoon.
Thank you.
She wants to receive today. She needs to pay me in here.
I can bring it up, is that okay?
Just do it to me.
People versus Brochu, case number 235207. Come right up to the podium there, please.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson.
Okay, so Mr. Brochu, I've received a number of letters from you that I've had a chance to review. The first thing I guess I want to address is you're asking to have Mr. Thompson replaced.
Well, it was, I feel that this has been nothing but a joke. This is no joke. I see the guy in question is sitting in this courtroom, which is also a good thing because I'll be pressing charges against him as well. It's fine if he stays on, but yeah, I'm probably after today, probably gonna, depending on how this turns out, I'll probably be requesting that I get a different attorney.
Okay, so I'm not sure, you want Mr. Thompson to stay on as your attorney for today?
For today,
Okay, so just so that you understand, Mr. Thompson, you're appointed on this case, is that correct?
correct.
Okay, so Mr. Brochu, at any point, you can hire your own lawyer. Okay, you understand that, you have the right to do that.
Yes,
Okay,
I was gonna go through another court appointed attorney, but at this point, he couldn't talk to me.
yeah, so that doesn't explain that process to you, okay? So you can hire your own attorney anytime you want, and that person can replace Mr. Thompson at any time. If you are asking for a court-appointed attorney, then there's a process that we have to go through. You can't just say, I want to hire my attorney and it automatically happens because it's a court-appointed lawyer. The public is paying for your lawyer. And so if you want to request a different attorney, then you've got to file that request with Mr. Thompson's office. And then they'll make an assessment. If they don't change your attorney, then you can appeal that to the court, but you're going to have to follow that process if you want to replace him, okay?
Yes, sir.
In terms of, wanting to file complaints against other people, that's not something that the court does. So you would have to get a lawyer or do it yourself, file any kind of civil case against anyone else. If you want to seek criminal charges against somebody, you would have to talk to the prosecutor. She's the one that files criminal charges against people. But as the court, that's not what I do. I just terminations. once cases have been filed.
Just so you know, yes, the person involved in this case, I will be, once I get out, which I'm hoping I get sentenced today, so I can talk to the prosecuting attorney and make proper police reports, because I have filed in the court or in the jail to the police, but nothing can be done while I'm sitting in jail, but I will be talking to the prosecuting attorney and pressing charges against the individual that's sitting in this courtroom today.
And that's fine. What I want you to understand is you're writing me letters telling me that you want the court to do that, and that's not the court's role. So I just want you to understand that no matter how many letters you write to me, I can't press charges against somebody. I can't file lawsuits against somebody on behalf of the court. I just want to make sure you're clear, like how it works.
Oh, I'm clear.
I don't want you to feel like you're being ignored or I'm not doing anything about it. It's just not the role of the court to file lawsuits or to press criminal charges, okay? In terms of how we're gonna proceed today, Mr. Thompson, can you tell me where the case itself is at?
There's a plea offer in this case, Your Honor, that the prosecutor would dismiss count 2, would reduce count 1. Charge that be dropped to an attempt. So in exchange for attempted count 1, dismiss the 10-year and dismiss the count 2, Your Honor. It's my understanding, speaking to Mr. Bruce last week, he wants to take advantage of that.
Is that correct, Mr. Bruce?
Yes, sir.
Ms. Koch, is that a correct statement of the offer?
It is, Your Honor, and that makes it from a high severity down to a low severity felony.
Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Mr. Brochu, are you currently on any kind of probation or parole?
No, I was taken off of probation in Charlevoix this month.
And you understand that by pleading guilty to attempted retaliating against a witness, that the maximum penalty you could face would be up to 5 years?
Yes,
That maximum penalty in mind, what is your plea to that charge today?
guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights.
Yes,
You understand that by pleading guilty, you're giving up and waiving all of those rights.
yes,
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. No, that any appeal, you understand that?
yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court?
no,
Is it your own free choice to enter this plea?
yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
So the date that I have on this is June 21st of 2023.
Yes.
Is that the correct time frame?
Yes,
And let's see. Let's go for Mr. Thompson. Can you flesh out the factual basis here?
Yes, so Mr. Bruce, you previously had a probation violation case in Charlevoix County, correct?
yes,
All right, and was this William David Roberts was a witness in that proceeding?
yes,
All right, and you went to the home of Harry Wildfong on the day in question.
yes,
Okay, and you were you encountered Mr. Roberts there.
yes, I did.
You were very upset with him.
Yes, I was.
Okay, you had a knife that you were brandishing.
Yes,
Okay, you were yelling at him.
yes, I was.
And you believe those actions make you guilty of retaliating against Mr. Roberts, correct?
Yes and no. Yelling at him. It was the point that it's been an ongoing problem for a year. that lived at Harry Wildfowles. Him stalking me, whatever. But yes, I am guilty of supposedly retaliating against a witness, but
Well, you understand that by you brandishing that knife in that manner, that would make a reasonable person be concerned they're about to be assaulted. correct?
yes,
All right, I'm good for
And
that.
that was related to his testimony against you.
yes,
And that all occurred in Crawford County, Mr. Ruscio.
yes,
All right, I don't have any further questions.
Ms. Coke, are the people satisfied with the factual basis?
Did we establish that that was in Crawford County? Okay, yes.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No, Your Honor.
Ms. Coke, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Thompson?
Yes, Your Honor.
Thank you. Mr. Brucci, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept a guilty plea. We're going to set this matter for sentencing hearing. Today, you're going to meet with one of the probation officers. They're going to get the process started for the pre-sentence report. And then we'll go forward from there, okay? Ms. Coke, anything further on this case today?
No, thank you, Your Honor.
Your Honor, I know Mr. Ruscio would like the court to address his bond or, I understand, of course, not going to sentence you today, but I believe Mr. Ruscio would like the court to visit his bond, consider a PR bond.
Your Honor, I wasn't aware that we were addressing bond today. He pled guilty today to an egret offense. I do not know what his criminal history is, or what he will score out at. So I don't have any additional information for the court. The court's aware of what happened and the crime that he
All
pled
right,
to
I think
today.
based on the nature of the charge in this case, the court's going to order the bond remain the same. We'll get this set for sentencing at the court as soon as possible date. Mr. Brochu, I know you want to get that sentencing date after that. So I'll set it as quickly as I can, but the court's not going to honor that. So we'll notify you the date and time of that hearing. That's all for today. Thank you. Ackerman, case number 234.
Sierra Coke on behalf of the people.
Mr. Ackerman, you can write up the podium here, please. Thank you.
Thank you, Your Honor. Jason Thompson, defendant Travis Ackerman.
Thank you. Mr. Thompson, how do we want to proceed on this part?
Your Honor, I'd like 30 days to file a motion to stop this matter. Proceed on that basis, Your Honor.
All right, Ms. Coke, any objections to that?
No, if we ask for an additional adjournment, though, I will be objecting at that point.
So the court will adjourn for 30 days. For Mr. Thompson. Ms. Coke, anything else I can address for your side today?
No, thank you, Your Honor.
Mr. Thompson?
Nothing else for today, Your Honor.
Mr. Ackerman, any questions about how we're going to go?
Your Honor, could I just ask, Trev, what's your current mailing address?
I don't know, I had a PO box, David.
Okay, is that what you have, Ms. Neville?
I did not even hear him.
He said there's a PO box
PO
in
box.
Gaylord.
Yeah, that, it's not Charles Street address.
No.
Sorry, I know he moved since the case was filed.
I have the Charles Street address crossed out.
I have a PO box 95 in Gaylord.
Okay. Double checking that. Thank you.
Okay, thank you. So far, yes.
Yep.
You ready on Mr. Charis case? Versus Jared Charis, case number 235177.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trish on behalf of Mr. Shaw.
Mr. Trush, can you tell me where you're at with this file?
Your Honor, we're set for a trial, I believe, about a month from today, and we intend to proceed to that trial.
Got it set to begin on November 14th.
Yes, so that is the only trial that will be going that week.
Okay, so Mr. Trush, we don't have any other files set, so your case will have priority and the court will not need to move it based on its document. So, Ms. Koch, are the people going to be ready to proceed as scheduled on the 14th?
We are ready to proceed. The offer in this case was a misdemeanor. So of course, we have a record.
And
I have it set for one.
one day, okay.
That's my recollection as well.
Okay. Ms. Koch, are there any freestyle motions or any evidentiary issues that are going to be resolved prior to the trial date?
We may be filing, I think we've requested the reports for a 768 notice, but other than that, no.
Okay. Mr. Trush.
No, we don't plan to file any motions.
So we'll proceed with trial on the morning of the 14th. The court won't have any further hearings. So Mr. Chair, it's important that you stay in touch with Mr. Trush leading up to that date. Mr. Trush and Mr. Chair, so we'll ask that you both, as well as Ms. Koch, are present, ready to go at 8:30 on the morning of trial. Ms. Koch, if you could submit your proposed jury instructions as indicated on the pretrial order. Mr. Trush, I don't need you to submit a full copy, but if you can submit to the court any objections or any additional instructions that you're requesting. Koch, anything else on this file that you're
We are prepared for trial. Thank you.
No, thank you.
Mr. Terrace, do you have any questions? Okay, thank you. That's all for today. Versus Schweitzer, case number 235-228 and 5239.
One, two.
Schweitzer, if you want to come right up over here.
That's Ford. That's carried forward.
Ford.
Yes.
We're on the record. Sir, the record should reflect Ms. Schweitzer present here in the courtroom today.
Your vote on behalf of the people.
Thank you, Your Honor.
This is the date and time set for sentencing this matter. And if you had a chance to go through the pre-sentence report and talk to Mr. Trush about that. Mr. Trush, are there any additions that you would correction?
No.
Some challenges to the scoring of the guidelines.
No.
No.
Both of the people have any additions to correction.
No, Your Honor.
Challenges to the scoring.
No, Your Honor.
Anything on behalf of the people for allocution today?
Given the files and the plea agreement, I think the recommendation is appropriate. I'd ask the court to follow it. Thank you.
Mr. Trush,
Yes, Your Honor. You know, what I would indicate here, obviously, I don't think there's any question based on the charges in the conviction here and the history of the case. Schweitzer has an issue with substance abuse. it's something that she needs to address. I know the court gave her an opportunity to try to address that prior to the sentencing here. And frankly, that didn't go as planned. The recommendation here, I don't think it's crazy given what the guidelines range is. I would just ask the court to consider crafting a sentence that would allow her potentially to attempt to take advantage of a treatment facility at some point during the sentence if the court does choose to impose the additional 60 days requested.
Right, and just along those lines, I'm just noticing that credit is at 30 days, that's 397.
It should be add 24, so it should be 54 total, Judge.
Wait, anyone to say that?
Just that I'm grateful for the opportunity that the court gave to me. I'm sorry that I squandered it. I just was going through a really rough time and I was really uncomfortable with my first time. So I was really uncomfortable and wasn't too far away from my support system. So it just freaked me out and I didn't think, I just kind of did, I guess I had to. And I apologize for that. Give me
So I did review the report, I'm familiar with what happened. Underlying charges here, I'm familiar with, obviously that, you went to treatment and then left. I think that the recommendation overall is appropriate, and I think, the court needs to impose a sanction for you leaving treatment early. Not just as a punishment for you, but I do give that opportunity to people. And, other folks need to see that if they get that opportunity, they don't do it, there's penalties you pay for that. But, we're gonna put you on probation for a period of time. You can have an opportunity through probation to seek treatment again, and I think you should keep trying. Now that you kind of know what it's about, been there for a little bit, you kind of know a little bit more what to expect, but that's really, that's an important key to going forward. It's getting some inpatient treatment, as uncomfortable and not fun as it is. It's way more productive than just being in jail, because that's not going to get you anywhere. The treatment's what's going to help you going forward. So the court is going to impose 90 days in the Crawford County Jail. You do have credit for 54 days served. The court is going to place you on probation for a period of 18 months. The court's going to adopt as the conditions of your probation all the terms and conditions listed in the report. That includes to participate in and complete any outpatient or residential substance abuse treatment that's recommended to you. So it's going to order a crime victims assessment of $130, court costs of $325, attorney fees of $50. There's 2 files, so there's a state cost of $136. And then a supervision fee of $30 per month while you're on probation. That all relates to count 22 and the bounty of 5228. As to count 3, same file, 30 days in the Crawford County Jail, credit for $30 state cost. You could have the ability to appeal the sentence, and Mr. Trush is going to give you some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer if you want to. And good luck to you going forward.
Thank you.
Versus Myers, case number 235185.
Sierra Coconut, you have the people.
Thank you, Your Honor. On behalf of Ms. Myers.
The date and time set for sentencing in this matter. Ms. Myers, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that? Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Pope, do people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocution?
You know, I found the defendant's recollection of what happened or allocution in the PSI to seem unlikely, given her past history. She previously had the operation of a meth house and got that pled down to the possession. And then she has another pending delivery case in Roscommon. So to make it sound as if this had never happened and she suddenly just did this as a favor, I just didn't find any of that to be realistic at all. I think that the guidelines are 51 to 85 months, and I think she should be scored in the middle of the guidelines or the lower end. But either way, I think she should be scored within the guidelines. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. This is a unique case for a few reasons. I mean, not the least of which is, of course, well aware, methamphetamine cases score out very high. They're on the B grid, which is basically about as high as you can get outside of, cases involving murder or sexual assault. The facts and circumstances of this case, though, are a single incident that involves a very small amount. It involves 2 grams. The prior history here is limited to a single incident that occurred over 10 years ago. And I mean, it occurred, I think, in 2012. I think the conviction is in 2014. I bring those things to the court's attention because, frankly, the guidelines here, I don't think, do an accurate job of capturing what occurred. I mean, what I think the history here shows is that she absolutely has a problem. She has a problem with methamphetamine. Again, the history would show that, the pending charge would show that. What I don't think it shows, though, is, again, on that scale, right? You have this scale of someone who is, a user who maybe sells to support their habit versus someone who is selling for, profit and bringing, trafficking amounts of drugs into the community. That's not what we have here. What we have here is a single delivery with an extremely small amount, 2 grams. We have a prior history that's limited to 2 convictions that come out of 1 incident over 10 years ago. Frankly, Your Honor, I don't think that the guidelines accurately capture what's going on here, specific to Ms. Myers. I would suggest to the court that this is a case where I would ask court to use its discretion to deviate from the guidelines and sentence her in a way that might make her eligible at some point for treatment in the boot camp program. Again, she has no prior stints in MDOC, so it would seem appropriate to give her an opportunity on her first stint to take advantage of that program. But because of the B grid and because of that history from a long time ago, I mean, basically as old as you can get without it not counting under the guidelines, the guidelines don't avail her that opportunity. I don't think this shows where Ms. Myers is, again, in her process. I would indicate Ms. Myers was employed up until the end of last week, where she voluntarily left her job knowing the sentencing today had a prison guideline. So again, I would indicate, I think this doesn't accurately capture what's going on here because of the history of the prior conviction, as well as the extremely small amount at issue in the case here. And again, that it's a single incident. So I would ask the court to deviate downward from that and make her eligible for treatment in the boot camp program.
All right, thank you. Ms. Myers, anything that you wanted to say today?
No, Your Honor.
You were shaking your head to some of the things that Ms. Cope was saying. Was she saying something not accurate?
I was not operating a meth house.
Well, what she indicated was that you were charged with that. You were charged with 4 counts of operating a lab involving methamphetamine.
That's news to me because I was not.
That's what the records indicate. Was there anything else about what she was saying that was incorrect?
No.
When you were shaking your head, it sounded like she was saying something that wasn't true, and I want to make sure that I have the accurate information. Okay.
I was not operating in that house.
All right. I did have a chance to review the pre-sentence report in this case. I looked at your record, looked at the circumstances of this file. I don't know I don't know why you were selling this amount to this person. I know what the report tells me. Yeah. That's what you were.
I was pressured into it. Guilted into it, bothered, like repeatedly called and guilted into doing it. I repeatedly told the person that no, I wasn't gonna do it. It was my niece. I have text messages from her saying that she pushed and pushed and pressured me into getting it for her. After repeatedly telling her no. And you can only take so much, being asked and bothered, I mean, daily, and then you get guilted into it, so you do it. I wasn't dealing, I wasn't doing anything else, I wasn't using, nothing. And it just, I don't know what else to say.
And maybe we look at it from different perspectives. I don't think anybody could ever say anything to me that would get me to get some methamphetamine for him and then sell it to him. I think, going forward, you may want to consider that regardless of what the substance is or how much somebody's bothering you for it, it's not worth you going to prison, right?
No, it's not.
No, it isn't. And I think just reason and common sense would tell you that no matter how much somebody bothers you for a substance like that, you just don't get it for them. I mean, the answer is just no, sorry. And the fact that somebody's able to exert that much influence on you in the form of guilt or some other type of feeling that you would be willing to do that for them, I think that's also something that you probably need to look at in terms of your own outlook on things.
So what happens when family does it?
Again, I mean, I've got family and I don't care how many of them came out of the woodwork to ask me for methamphetamine. I'm not giving it to them, period. Again, I think reason and common sense would tell you it's not something to do. And you did it, and you have to accept the consequences for that. And I don't get the sense that you are at all. I mean, you want to blame her for it. You're the one who did it.
I'm not blaming her, I wasn't dealing drugs to anybody.
But you did sell drugs to somebody. And that's dealing drugs. You need to accept responsibility for what you did. You're not doing that at all. I think there are some mitigating factors here. Certainly the amount is absolutely a mitigating factor because it wasn't a lot. I agree with you. You weren't selling it on a consistent basis. You weren't bringing tens or hundreds of grams into Crawford County to distribute into the community. And the first thing that I thought of, aside from everything else, is the recommendation and the guidelines seemed high to me, given your conduct in this case. And generally, it's not the court's position, and I have folks making arguments in front of me all the time about methamphetamine and how it's not fair what people get sentenced to, and asking the court to ignore what the legislature's done, because as a society, through our legislature, we determined that methamphetamine is a dangerous substance, and to discourage people from being involved in it, they're going to impose heavy penalties for it. And it's not my place as a judge in the judicial branch to override what the legislature has decided. And what we've decided as a society through our legislature. So I don't find that to be a convincing argument at all. What I do find to be a more convincing argument is the age of your prior conviction, the amount of substances at issue here, and the circumstances. And all of that I say to say that, and I've 10 years on the bench, I've done this less than 5 times, I do think that the guidelines here are disproportionate for the conduct that you engaged in. And despite what I view as a lack of accountability on your part of your actions here, I think this is a case that warrants a downward departure, and a departure that would allow you to be eligible for the boot camp program. If you are, that's something that the Department of Corrections is going to decide. That's outside of my scope, but I do think imposing a sentence that leaves that as a possibility is appropriate. So the court finds that because of the mitigating circumstances here, again, the amount at issue, the fact that it was a single instance of sale, your prior convictions being for incidents that arose in 2012, although the conviction, as Mr. Trush gave, was 2014, nearly a decade ago. All of that warrants, in my view, a downward departure, because I don't find the guidelines in this case to be proportionate. So the court is going to sentence you to 36 months to 20 years in the Michigan Department of Corrections. You do have credit for 2 days served. The court is going to order restitution in the amount of $180. Crime victims assessment of $130. Court cost of $325. Attorney fees of $350, and the state cost of $68. You do have the ability to seek an appeal of the sentence, and you can provide those elements. Ms. Myers, please.
I do have that executed advice of appellate rights for the court. I'm tendering her copies to her.
Myers, you are remanded to the custody of the state. Versus Carrie Ford, case number 225139 and 235209.
Your vote on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Ford.
Ms. Ford is present here in the courtroom today. Time set for sentencing. We're going to get a chance to go through the order of Dr. Mr. Trush. Reprogramming, additions, deletions, or corrections.
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Both of the people have any?
No, Your Honor, I just wanted to make sure. Did we call both files?
I did.
Okay, yes, nothing further, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocution?
Yeah, I think the PSI lays everything out. I think the recommendation is appropriate. I know that she's gotten a verification of eligibility from Harbor Hall. That can be a 90-day stay. I think that would be appropriate at some point in her stay, whatever the court feels is appropriate. Thank you.
Mr. Trush?
Your Honor, I would say I think the PSI in this case really does accurately reflect everything. I think in this case, the recommendation is very appropriate. Ms. Ford has secured eligibility for basically immediately to be able to go into a rehab facility. The recommendation, I think, suggests to the court that she should be allowed to do that and allowed to receive credit for it. Again, that would seem appropriate. She has served a pretty significant amount of time sitting in the jail as this has been pending. And I would also indicate, as the court's probably aware, there is CPS involvement in regards to her son. She has been engaging with that. I mean, this is a struggle for her. It has been, the court's obviously aware of that, as we're also hearing a violation hearing. But I think what is probably the thing that bodes most well in this case is she continues to make efforts. She's continuing to try to address the issue. And frankly, as I think everyone here no doubt knows, it's not a straight line. If it was, we'd never have people coming back here, but she's continuing to put the efforts in and try. And hopefully if she gets into a long-term treatment facility, that will help her get a grip on this.
Ms. Ford, anything you wanted to say today?
Just that, I would be grateful to have the opportunity to seek treatment and get back to my son in my life.
I did review the report prior to the hearing today, so I'm familiar with what happened here, as well as your circumstances. Obviously, we got some issues with this case. But I do think that the recommendation is appropriate. It calls for 5 months jail. You do have credit for 72 days served. I think if you are eligible for release of treatment, which it looks like you are, that you're bed ready to be tomorrow. Then the court would allow you to go to treatment. If it's a 90-day program, that's basically going to take up the entire 5 months. So the court would give you day for day credit if you successfully complete it. If you don't, you're going to have to come back to jail and finish that 5 months, no matter how much time you've been in treatment. So as I told Schweitzer earlier, your time is much better spent in treatment than it is sitting in jail. So that's not getting anywhere. So if the court is going to sentence you to 5 months in the Crawford County Jail, you have credit for 72 days served. The court will allow you to be released to treatment for the balance of that time. If you successfully complete treatment, the court will give you day-to-day credit off the remainder of that sentence. If there's still time remaining after you finish treatment, if you successfully complete it, the court will hold the remaining time in advance. If you fail to successfully complete treatment, then you would be required to serve out that balance of the 5 months without any credit for any time in treatment. The court will order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Trush can provide those rights.
Judge, for her to be released from treatment, typically the defense attorney does that order. So is that something, Mr. Trush, you're going to be working on so she can be released tomorrow?
I'm sorry, I didn't catch it.
Mr. Trush, we're going to need you to prepare an order for her to be released to treatment if she gets that available tomorrow.
Oh, absolutely, I can do that.
Richard, I sent out Jason has the addendum. It's already done. You just have to check the boxes that was pre-approved.
Excellent. Makes it even easier.
Just she's got her PV file. That 5139. That goes.
Oh, I thought you both work together.
Judge, in lieu of her sentence on the new felony file, I would just dismiss that violation on the 5139 file and continue her on probation with all prior terms and conditions.
Okay, all right. Thank you. If you could just prepare an order that reflects that.
Thank you, Judge.
Our next hearing set for 3:45. We'll take a short recess for about 10 minutes. versus Burr, case number 235200.
Your clerk on behalf of the people.
And on behalf of David Burns,
Thank you. Mr. Vernon, how do we want to proceed on this?
after conversation with my client, and the understanding that there is no plea offer in this matter, my client has agreed to plead guilty to count one as charged. With the understanding in conversation with Ms. Coke that the penalties under SOAR are 15-year registry.
Mr. Burr, have you had a chance to talk to Mr. Vernon about this plea agreement?
Yeah,
Or I'm sorry, this plea today?
yes.
You have, do you need any more time to do that, or are you ready to proceed?
No, I'm ready to proceed.
Raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth. So help you God.
Yeah.
Where are you currently on any kind of probation?
No.
All right, you understand that the maximum possible penalty that you could face by pleading guilty to count one is up to 2 years and or a $500 fine, and the registry is indicated by Mr. Vernon.
Yes.
That maximum possible penalty in mind, what is your plea to that charge today?
Yep.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand that you have all of those rights.
Yes.
And you're waiving and giving up all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here today in court?
No.
Is it your own free choice to enter this plea?
Yeah.
Are you pleading guilty because you are guilty?
Yes.
All right, Mr. Vernon, there's really not much detail in the information here. So I'm going to ask that you conduct some questioning of your client to establish a factual basis.
Do you want me to use the minor child's name or the initials as identified in the recommend?
Just initials.
Okay. Are you familiar with the minor child AH?
Yes.
And how old is that minor child?
13.
And on the date in question of 3/29 of this year, were you in Crawford County with that minor child?
Yes.
Did you have sexual contact with that minor child?
Yes.
Specifically, what did you do?
I touched her crotch over her pants.
And did you do that for the purpose of accomplishing sexual contact?
Yes.
Did you do that for the purpose of sexual gratification?
Yes.
Did you know at the time she was 13?
Yes.
I believe that satisfies the elements.
Ms. Koch?
I agree that it satisfies the elements.
Ms. Koch, are the people aware of any threats, promises, or inducements?
No,
Mr. Vernon, are you?
I did go over his guidelines with him. That may have acted in some form as an inducement.
Okay. Mr. Burr, you understand that while Mr. Vernon has calculated and come up with what he believes would be a likely guideline for your sentencing, that the court isn't bound by that, and it may in fact be different once the probation department looks at it.
Yes.
Any other
No.
issues, Mr. Vernon? All right. Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
yes, Your Honor.
Mr. Vernon?
I am satisfied.
Or the court finds that your plea is knowing, voluntary, accurate, the court is satisfied there is a factual basis to support a finding that you are guilty of this charge, the court will accept your guilty plea. This matter for a sentencing hearing, you'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Vernon prior to that date, okay?
Yeah.
Also, before you leave court today, you're gonna meet with one of the probation officers to set up a pre-sentence. Ms. Koch, anything else you need to address on this file today?
I was given a copy of the psychological evaluation and sexual risk assessment. I made a couple underlines on it, but I wanted to confirm with defense counsel that this should be turned over to MDOC.
We would ask that be made part of the recommendation in the court file, yes.
Okay.
You want it included with the pre-sentence
I do.
report?
And additionally, I'm sorry, are you?
Yeah, that's all.
Additionally, Your Honor, we had signed, pursuant to the court instruction, a stipulated protective order regarding recorded statements from the victim and returning those to the prosecutor as instructed.
Thank you.
People versus Terry Johnson. Case number 235233.
Sierra Coke on behalf of the people.
Johnson present. That's that for the moment. Mr. Blumberg, were you ready with your client?
Yes, Judge.
We'll go on the record in People versus Bolander, case number 225140. Mr. Bolander, if you want to come up to the podium there, this is the date and time set for sentencing in this matter. If I could have counsel.
Sierra Coke on behalf of the people.
Good afternoon, Judge Elliott Blumberg. Excuse me.
The date and time set for sentencing in this matter. Mr. Bolander had a chance to go through the pre-sentence report with Mr. Blumberg.
I have not. Yes, you have. Did I? Months ago. Yeah. Okay. Maybe I have. Yes, Your Honor.
More time to talk to them today before we go forward.
No, I'm also.
Mr. Blumberg, are there any additions, deletions, or corrections to that report?
No, Judge, we believe it to be factually accurate as far as it goes.
Thank you, Ms. Coe, or I'm sorry, are there any challenges to the scoring of the guidelines?
No, Judge.
Ms. Coe, any additions, deletions?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, we have adjourned this case, I don't know how many times, 6, 7, 8 times, over a pretty lengthy period of time because of Mr. Bolander's health issues, and I think Mr. Blumberg will get into that. The recommendation here is very light, I think, in light of all of those things that's been going on with Mr. Bolander. This is his 4th OWI. He did have one in 2018. The other ones are old, 1992 and 1994. I think the recommendation is appropriate. I understand that he has some health issues that the court may need to address. I think had he not have those health issues, given his criminal history and the situation here, him being at a 0.189, we're likely to see a 6 to 9 month recommendation. Thank you.
Mr. Blumberg?
Judge, certainly the facts of the underlying case are such that the recommendation is appropriate. However, Mr. Bolander's current situation is not a regular situation. He's just survived open heart surgery. He had a pacemaker put in, a valve replacement done. There was an infection which resulted in opening him up again. From what I've been informed by his healthcare providers, he flatlined twice on the operating table. So certainly he is in no condition to go to jail. We would ask the court to consider seriously imposing either a house arrest or an electronic tether. He has cardiac rehab all scheduled, and he may be going back in for more surgery. Certainly a period of incarceration would place him in grave danger, and it would probably create a reasonable cost for the county if they had to pay for those medical procedures. So I haven't addressed particularly the underlying offense. He's had multiple drunk driving convictions. There's no getting around that. He doesn't drink anymore, but the important thing is he recognizes the seriousness of those offenses, and right now his main concern is staying alive, and his health is such that incarceration would put him at grave risk. I think that there is an alternative to incarceration, and we would ask the court to seriously consider imposing a house arrest that would allow him only to go to his doctor's appointments and stay at home and not be allowed to go anywhere else during that period of time that he's supposed to be in jail. I know it's somewhat of an unusual request, but the facts of this case seem to support that, Judge. And I know the last time we were here, you at least made a comment that suggested to me that the prosecutor and I could suggest to the court an alternative to incarceration. Unfortunately, the prosecutor and I have a different view of that. So I know that you have that discretion and would ask you to exercise it.
All right, thank you. Mr. Bolander, anything you want to say?
I'm deeply sorry for what happened that night. It was selfish of me to do that. I know better. I was going through a little bit of rough patch, have been the last few years, but now I've gotten over that. Drinking is not an option for me anymore with what I've been going through. 10 weeks ago today, I fought the hardest fight of my life. And I'm just happy to be here. And I want to be able to take care of myself. Make my appointments, do cardio rehab and whatnot with my doctors to be where I'm at.
All right, well, I read through the report. I've read through it a number of times based on the adjournments that we've made. Not saying that those weren't reasonable adjournments, but I've had a chance to read through the reports. I'm well familiar with the facts of what happened here. Certainly your behavior on this night is very concerning to the court from a public safety standpoint. Others certainly could have been injured much more than they were. And the operating vehicle out on the roads. The court has an interest in discouraging that kind of conduct and punishing that kind of conduct. Certainly the fact that you've been down this road before, it's not a case where you're learning a new lesson here. You know already that this is conduct that's not acceptable. I do think jail time's appropriate. I don't think that perhaps at this time, if your conduct here justifies possibly creating a fatal situation for you in the jail. But we're going to put you on probation for a period of 18 months. And at some point during that time, you're going to have to serve 30 days in jail. So you can decide when, based on your health condition, and discuss it with your probation agent. If during that period of time your condition gets worse or you're not able to serve that jail time, then the court's going to have a written documentation from a physician that directly addresses that before I would be willing to waive that jail time. Because again, I think a punishment that's appropriate and health condition shouldn't excuse you from serving punishment. But I am, again, recognizing the seriousness of your condition. I'm not willing to put your life in jeopardy to do that, but at some point you're going to serve that time. So the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. You will be required to serve 30 days in the Crawford County Jail with credit for 1 day served. That time to be served at some point within that 18-month period. Once you've got clearance from your medical professional to do that. If your doctors are telling you that at no point during that time are you able to serve 30 days in jail, the court's going to require that you provide written documentation of that to your probation agent, and you may need to have another hearing on that. The court is going to propose a reimbursement fee for the alcohol testing of $100, a $68 state cost, crime victims assessment of $130, court costs of $325, a fine of $500, and then the supervision fee while you're on probation of $30 per month. If I didn't say it, the court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. You do have the ability to seek an appeal of the sentence, and
I don't.
I think it's underneath your brief.
I'm sorry.
I'll just need to initial
Reflect Mr. Bolander has acknowledged receipt of the notice. He's initialed it and dated it.
Okay, and then we need the 2 top copies for us.
I get the top copy. He gets 2, prosecutor gets 1.
And then, Mr. Bolander, before you leave the courthouse today, you're gonna need to check in with your probation agent.
Thank you, Judge.
Thank you, that's all for today.
Thank you, Your Honor.
I'm gonna recall People versus Johnson. This is case number 235233. This was set for hearing at 3:45. That's now 4:06. Neither counsel nor Johnson are present physically in the courtroom or by Zoom.
And he's not
Have you
lodged?
had contact with opposing counsel in that case? Huh?
Yes, Mr. Johnson just got picked up a few weeks ago in another OWI. I'll text Mr. Trush.
This shows Randall Harbor as his
Oh.
attorney.
Do I have the right attorney? Yeah.
Hold on. I haven't-
Here, number. Oh, no, but she does have Mr. Trush. I don't have any email. The defendant.
Do you know if he's currently lodged somewhere?
It was here that he got picked up. So if he's not lodged here, then I'm not familiar with him being lodged.
All right, well, based on his failure to appear today, I'm gonna request that your office prepare bench warrant for his arrest. That is bond be revoked. That he be lodged until the court will schedule a hearing once he's arrested.
Okay.
Mr. Turner, if he's ready with our last case. It's on Mr. Shepherd.
Richard said he did not get notice of this.
Correct, because Mr. Harbor was the attorney. I just changed it.
All right.
But I didn't hear anything from Mr. Trush's office or the defendant.
Okay. Does that mean that Mr. Johnson didn't get notice though?
He got his notice.
Okay.
Are you ready with your,
Yeah.
Mr. Shepherd?
Mr. Shepherd, judge is ready.
Everything come up to the podium. We're on the record in People versus David Shepherd. We got file number 235179 and 5180. The record should reflect Mr. Shepherd present in the courtroom today. I could have council put your appearances on.
Sierra Coke on behalf of the people.
And Ralph Gurmati on behalf of Mr. Shepherd, Judge.
Mr. Gurmurthy, where are we with these two files today?
Judge, we would ask you to set this on the trial docket with a plea cutoff date. And I believe we would need a one-day trial in this matter.
Okay, and both cases would be tried together.
Correct.
Ms. Coe, in terms of the duration of trial, how many days? You think?
I think I can do this in one day, Your Honor.
You said one day as well, Mr. Gurmurthy.
I believe we could do this in one day as well, Judge.
So we'll set it for a one-day jury trial. Ms. Coe, do you need any particular period of time to be ready to proceed?
No, Your Honor.
No.
So we'll set it for as soon as trial date, one-day jury trial. Ms. Coe, are you anticipating any motions of limine or evidentiary matters that are going to need to be resolved prior to trial?
I don't believe so.
Sure.
There was an issue of ownership, and I'm going to explore that further, so that may prompt some additional motions once I explore that issue, Judge.
So we'll set it for a final status conference on the motion day immediately preceding the trial date. Mr. Gurmurthy, that'll be the motion cutoff, so to the extent there are any motions.
Yes.
They would need to be filed and heard no later than that date of the final status conference. Same for people if they have any motions. And then that will also be the plea cutoff. So that would be the last case. Send out trial notices. Let's go.
No, Your Honor.
No question.
Okay, thank you. That's all for today. Just make sure that you stay in touch with Mr. Gurmurthy.
Okay.
With their afternoon docket, the court will be in recess until 9 a.m.